Good morning, ladies and gentlemen. Before I begin, I'd like to ask each commissioner and the audience to please take a moment to silence your cell phones, and for commissioners to move your phones away from your microphone. I'd also like to note that we have a sign language interpreter available for anyone who may need one. Those who need those services, please contact Pam Dunstan. Ms. Dunstan, please raise your hand so folks can see you. Thank you. This hearing is called to order. Today we embark on a continuation of the hearing that we started on April 23, 2010, examining the Justice Department's handling of voter intimidation litigation involving the new Black Panther Party. This hearing is being conducted pursuant to 42 USC Section 1975A and the Commission regulations at 45 CFR Section 702. I'd like to thank all the commissioners here today who worked to arrange their holiday travel plans and vacation schedules to be here for this important hearing into the new Black Panther Party matter. We had to accommodate a number of schedules, including our witness and his attorney, as well as the commissioners. It's needed so that we can complete our investigation, finalize our report, and submit our report to Congress, the President, and the American people. So again, thank you I'd like to thank all the commissioners for rearranging your schedules to be here. In the course of this investigation, which began over a year ago in June 2009, the Commission has heard from various fact witnesses who witnessed the Election Day 2008 incident that is at the heart of our analysis. We've heard from Representative Frank Wolf, a former DOJ official Greg Katsas, and the Assistant Attorney General for the Civil Rights Division, Thomas Perez. As most of you are aware by now, the litigation stemmed from an incident on Election Day 2008 in which two members of the new Black Panther Party appeared at a polling station in Philadelphia. Video and eyewitness testimony show that they stood at an entrance to a polling place dressed in paramilitary garb and black combat boots. One brandished a nightstick. They hurled racial epithets at white and blacks alike, taunting poll watchers and poll observers who were there to aid voters. The Department of Justice at first aggressively pursued this case, filing voter intimidation charges against four defendants. The two new Black Panthers who appeared in Philadelphia, who appeared at the Philadelphia polling place on the election day, the new Black Panther Party chairman, and the organization itself. None of the defendants contested the charges, and the department was poised to seek a default judgment in the case and to seek an injunction to stop further acts of intimidations. But on the eve of the date which the court set for the department's request for a default judgment, the trial attorneys in the case were instructed to request a continuance by then acting Assistant Attorney General for Civil Rights, Loretta King. In the days that followed, and despite the robust justification that they had prepared at the inception of the case to support its request to file the suit, the experienced line career attorneys responsible for the case were put under intense pressure to justify the lawsuit against the Panthers, and they were required to prepare a defense of their proposed injunction and request for default. In addition, Ms. King sought a review of the matter by the division's appellate section, which agreed with the department that the department could make a reasonable argument in favor of default relief against all of the defendants, and probably should, given the unusual procedural posture of the case. And just to unpack that, the defendants did not contest the case. They essentially had defaulted. A total of at least 6 career attorneys intimately familiar with the details of the case shared this view, including the 2 who opined from the appellate section. Nonetheless, charges were dropped against all of the defendants but one, Minister King Samir Shabazz, who had wielded the billy club that day. The case against Jerry Jackson, who the other new Black Panther Party member at the polling station that day, was dropped, as were charges against the party and its chairman. Furthermore, the injunctive relief sought against King Samir Shabazz was limited to prevent acts of intimidation by him solely in the city of Philadelphia and only through Election Day, November 2012. Last month, we heard testimony from Thomas Perez, who's the Assistant Attorney General for Civil Rights, regarding the department's decision to largely dismiss the case. He testified that the facts and the law supported dismissal of the case against all but one defendant and the narrowing of the injunction sought against the defendant. This morning, we will present one witness, J. Christian Adams, a member of the trial team in the new Black Panther Party case, and a former DOJ lawyer who has resigned over the department's handling of the case. Mr. Adams has spoken publicly regarding what he views as the serious mishandling of the new Black Panther Party case and will answer questions for us today as a part of our investigation of this matter. Our General Counsel, Mr. Blackwood, will initiate the questions, following Mr. Blackwood, the commissioners will have an opportunity for at least 2 rounds of questions. Each commissioner will have 5 minutes per round, and we will proceed in the following order. I will go first. The Vice Chair is not with us today, and then the remaining commissioners in order of seniority. Commissioners may, of course, yield their time to one another. I may allow additional rounds of questioning as time permits. Mr. Adams, thank you for appearing before the Commission today. I'd like to swear you in. Please raise your right hand. Do you swear or affirm under penalty of perjury that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Kind sir, thank you for being here. I appreciate the dedicated service that you've provided over the years. And I want to recognize your courage for speaking out against what you believe is wrongdoing. At this point, I'd like to turn it over to our General Counsel, Mr. Blackwood.
Good morning. Mr. Adams, you're here with counsel today, is that correct?
That's correct.
Could you please identify him?
This is Mr. Richard Bolin.
Good morning. Now, Mr. Adams, you're here because the...
Did you have a question this time?
I don't right now.
You're here because of a subpoena issued by the Commission, is that correct?
It is, and I do have something I'd like to say about that.
Go ahead.
Okay. I would rather not be here to testify, despite reports to the contrary. I and my attorneys have invited the department to file a motion to quash to this subpoena, and we informed the department that we would not object to the motion to quash, and frankly would probably have encouraged it. Obviously, the motion to quash was not forthcoming. We were instructed, Mr. Coates and I, particularly me, that the Department of Justice would not enforce this subpoena against me, and that therefore I need not comply with the subpoena, which of course provides cold comfort to anybody who is under subpoena. For example, the department recently reversed a number of declinations not to prosecute from the previous administration and reopened the examination in a number of matters, which I won't detail here. So administrations change, and policies toward my dodging a subpoena in the future might also change over. Even if true, it seemed improper to tell me not to comply with a subpoena issued pursuant to federal law simply because I don't intend to enforce it and to comply with requests from the Commission as the law permits the Commission to do. Congress has noted, some members, that they want a special prosecutor appointed in this case to enforce subpoenas, which further complicated my legal position in not complying with a subpoena. The department has asserted a variety of privileges regarding this case, and these assertions of privilege have been the subject of debate by some very, very able attorneys, with some saying the privilege assertions are meritless and the department asserting they are legitimate. I had hoped executive privilege would be asserted to resolve the matter conclusively, but the department informed me that they had not exerted executive privilege. Nevertheless, in order to avoid these concerns, I will not testify about genuine deliberative process in this case, not because I concede those objections are valid, but because I have far different matters to testify about which have absolutely nothing to do with any colorable privilege relating to the Black Panther case. I will not discuss the mechanics or particularly the legal and factual debate within the department in the case. You already have one side of that debate presented by Mr. Perez in various department responses. On the other hand, Mr. Gregory Katz has testified to you and presented a legal analysis in his testimony that seeks to rebut many of the claims of the department. I'll not provide my opinion or recollection of those internal legal debates here. Please understand, therefore, that my attorney or I may have objections to answering some questions you ask regarding matters that may offend the department's position, whether correct or not, regarding genuine deliberative process.